adjudicates over this application. This jurisdiction stands on 4 legs, Your Excellency: personal jurisdiction, material jurisdiction, temporal jurisdiction, and territorial jurisdiction, Your Excellency. On personal jurisdiction, Article 5 sub 3 of the protocol provides that NGOs can bring applications before this honorable court, Your Excellency. In this case, EHRD is a civil society organization, Your Excellency, but it has been affirmed in plethora of cases that civil society organizations can bring applications before this honorable court, as it was affirmed in APDH and Cote d'Ivoire, Your Excellency. On the issue of material jurisdiction, Your Excellency, Article 3
what does that case state? What does that case state? I want to know the legal standard.
Much about, Your Excellency. It states that civil society organizations can bring applications before this honorable court, that they can fall under the categories of NGOs that can bring applications before this honorable court, Your Excellency. If I'm of no further assistance to this honorable court, may I proceed, Your Excellency?
Yes.
Much obliged, Your Excellency. On the issue of material jurisdiction, Your Excellency, Article 3 sub 1 of the protocol provides that this court has jurisdiction over cases and disputes to interpret the African Charter, Your Excellency. These proceedings involve the violation of the African Charter, Your Excellency, Article 1, Article 16, Article 24, and 11 of the African Charter, the violation of the International Covenant on Civil and Political Rights, the violation of Article 15 of the African Charter on Welfare of Right to Child, the violation of the ILO Convention number 182, Your Excellency, many amongst others, which was ratified in paragraph 2 of the fact of the case by the Republic of Edera, Your Excellency. Therefore, the subject matter is fully engaged, Your Excellency. On the issue of temporal jurisdiction, Your Excellency, we see in paragraph 2 of the fact of the case, Your Excellency, that the Republic of Edera had ratified the declaration of Article 34 sub 6 of the protocol on 2nd August 2017, Your Excellency. All violations that occurred between 2019 to 2025, Your Excellency. In AFCA, Bronstein, and Peru, this was held in an inter-American court, Your Excellency. It held that Peru's withdrawal cannot affect cases relating to violations committed prior to the withdrawal, Your Excellency. On the issue of territorial jurisdiction, all violations occurred within the Bashi region, which remains under the undisputed authority of the Republic of Edera, Your Excellency. It is the applicant's submission that this court has jurisdiction to adjudicate over this application, Your Excellency.
Sorry, can I please take you back to the issue of withdrawal? How is the withdrawal supposed to be done if there was to be a withdrawal, if there was to be a proper withdrawal?
Much obliged, Your Excellency. We see in the case of the withdrawal, Your Excellency, will take place after 12 months of the date, Your Excellency. This we saw in Inagbire versus Rwanda, Your Excellency, where the court held that the withdrawal of Article 34 sub 6 of the protocol can only take effect after 12 months, Your Excellency. If I take you to the fact of the case, Your Excellency, paragraph 29 of the fact of the case.
All right, I already have that point. Thank you.
Much obliged, Your Excellency. If I'm of no further assistance to this court, may I proceed to the issues of admissibility, Your Excellency? Much obliged, Your Excellency. On the issue of admissibility, it is the applicant's submission that this honorable court, this application, Your Excellency, is admissible, having fulfilled the requirements of Article 56 of the African Charter and Rule 40 of the Rules of Court, Your Excellency. It provides requirements that must be satisfied for this application to be admissible, that they must not be based exclusively on news reports, they must not be incompatible with the African Charter, that there be identification of the victims and the exhaustion of local remedies, Your Excellency. On the identification of victims, Your Excellency, we see in the case of African Commission and Kenya, this is the Ogik case, it held that victims need not be identified individually. It suffices if these victims constitute clear and identifiable groups, Your Excellency. In this case, the Bashi people and the child workers form clearly identifiable groups, Your Excellency. On the grounds of exhaustion of local remedies, Your Excellency, in paragraph 21 of the fact of the case, Makoa had filed an application before the High Court, which led to a cumulative decision in the Court of Appeal in May 2025, Your Excellency. On the issue of the treatment meted out on Mr. Jude Marcos, the arrest and prosecution and appeal to the Court of Appeal also took place in paragraph 28 and 29 of the fact of the case, Your Excellency. Local remedies have been duly exhausted.
In the first one, they still had the right to go to the Supreme Court. Didn't they have a right to go to the Supreme Court?
Much obliged, Your Excellency, for that question. In paragraph 6 of the fact of the case, Your Excellency, The Supreme Court's criminal jurisdiction can only admit cases where the sentencing is 5 years and more without an option of fine, Your Excellency.
No, not with regards to the criminal case. Not with regards to the Mr. Bashi case. No.
Yes, much obliged, Your Excellency. The Supreme Court can also only attend to matters which is related to compatibility of the legislation, Your Excellency. It is not of a constitutional question, Your Excellency.
Yes. Compatibility of what? Can you come again?
Compatibility of the legislation to the Constitution. It does not raise any constitutional question. The Supreme Court is there to have original jurisdiction to sit upon matters that raises constitutional questions on
It was not on we're not talking about original jurisdiction, we're talking about appellate jurisdiction.
Yes, Your Excellency. Apologies, Your Excellency. What?
Proceed, don't worry. It's fine.
Much obliged, Your Excellency. On the issue of the POA violating the international human rights instruments and the withdrawal of Article 34/6, whether it is valid, it raises a constitutional question which should have been filed before the Supreme Court, Your Excellency. But we submit that it was not required, Your Excellency, because the local remedies that were available were ineffective and illusory. We see in the case of Jawara and the Gambia, Your Excellency, it says that exhaustion of local remedies need not be sufficed, Your Excellency, where the local remedies are unduly prolonged and ineffective, which is the case, Your Excellency. And we have facts to establish this, Your Excellency. The first fact is that the violation occurred in the highest executive authority, the Office of the President. When violations occur from the apex of governments, local courts are structurally unable to give effective remedies. If we see Jarawa and the Gambia, the case, Your Excellency, the court held that the violations occurred from state officials, Your Excellency. That was why the local remedies that were made in that state were ineffective, Your Excellency. And so the exhaustion of local remedies had to be exempted in that case, Your Excellency. Second fact, Your Excellency, that the judiciary was compromised. If we take you to the paragraph 22 of the fact of the case, Your Excellency, we see that the Nigerian prosecuting authority and the judiciary were heavily influenced by big corporations and politicians, Your Excellency. This court may agree with me that a judiciary that has been bought cannot function as a remedy, Your Excellency. It is the applicant's submission that this application is admissible, having fulfilled the requirements of Article 56 of the Applicant Charter and Rule 40 of the Rules of Courts. If I am of no further assistance to this honorable court, may I proceed to the issue 1, Your Excellencies?
Yes, please.
What should about Your Excellency? Issue 1, whether the respondent's withdrawal of Article 34/6 declaration was invalid and contrary to international law, Your Excellency. It is the applicant's submission that the withdrawal of the Article 34/6 declaration is invalid for 3 reasons, Your Excellency. First of all, it failed to meet the test of the principle of legality. Going to the domestic root of the Republic of Nigeria, Your Excellency, paragraph 4 of the fact of the case. Section 17 of the Constitution of Nigeria gives power to the president to ratify treaties. However, treaties that involve international obligations, Your Excellency, and affect the vested rights of Nigerians, they have to be ratified upon parliamentary approval. In paragraph 1 of the fact of the case, Your Excellency, the Republic of Nigeria operates in a presidential system of government, Your Excellency. The unilateral withdrawal by the president in paragraph 29 of the fact of the case collapses the function of separation of power, Your Excellency, in democratic alliance versus the Minister of International Law, Your Excellency. South Africa wanted to withdraw its treaty, Your Excellency, but the court held that it was unconstitutional and it violated the principle of separation of power, Your Excellency. The power of a treaty to bind a state, it is shared between the legislative and the executive, Your Excellency. Though this section is silent on withdrawal, Your Excellency, the president's withdrawal, apologies, Your Excellency, the president's unilateral withdrawal, Your Excellency, collapses the function of separation of power. Though this silence does not connote power, it does not expand the executive's power to withdraw it, Your Excellency, because the parliament and the executive authority, they came together to ratify it, and so withdrawal should also take effect in that manner, Your Excellency. On the principle of necessity and proportionality, it failed to meet the state failed to provide that there was a pressing need, Your Excellency, to have warranted the withdrawal of Article 31st of 6 of the protocol, Your Excellency. And the measure it took was disproportionate to the events that occurred in Bashi region, Your Excellency. In paragraph 23 and 24, we see that these people had they lacked access to good water, soil, their environments were degraded. You could see in paragraph 24 the fact of the case that these people, they had to leave their houses for several hours, Your Excellency. This measure that strips citizens of their right to international remedy, Your Excellency, it is punitive and rights destructive, Your Excellency. Also,
But
it failed to meet the 12
month. If the international law is in conflict with the local laws, which law will supersede?
Your Excellency, may you rephrase the question? I didn't hear.
If the international law that we're looking at is in conflict with the local laws of EDERA, which law would supersede?
The local laws.
The local laws, okay, proceed.
Much obliged, Your Excellency. It failed to meet the 12 months notice withdrawal, Your Excellency. In Article 56 of the Vienna Convention of Treaties, it provides that treaties, for there to be withdrawal, it should follow treaty-specified conditions, Your Excellency. In Inagwere and Rwanda, Your Excellency, the court held that the withdrawal of Article 31st of 6 of the Declaration would only take place after 12 months of the notice, Your Excellency. In paragraph 30 of the fact of the case, this application was brought before this Honorable Court on 22nd August 2025. But in paragraph 29 of the fact of the case, the President unilaterally withdrew it on the 15th of August 2025. This shows that the withdrawal is still premature, Your Excellency. And so it is the applicant's submission that the withdrawal of the Article 31st of 6 of the Declaration is invalid. It was taken in bad faith to protect the state from international accountability, Your Excellency. And it undermined the principle of pacta sunt servanda, that agreements must be kept. Moving on to issues 2, Your Excellency. If I'm of no further assistance, may I proceed to issues 2?
Yes, please.
Much obliged, Your Excellency. Issues 2, whether the ROE violated the African Charter and other relevant human rights instruments by failing to ensure that the Bashi people and child workers are protected from violations committed by QHL. It is the applicant's submission that the Republic of EDERA failed to protect the Bashi people and child workers from the violations committed by QHL, Your Excellency. The state bears a positive obligation to exercise extreme due diligence to protect its citizens from violations that were committed by private actors, Your Excellency. In Sarak and Nigeria was held responsible for failing to exercise due diligence to protect the Ogoni people from the environmental devastation that occurred as a result of the oil companies exploring their land, Your Excellency. Also in Zimbabwe NGO Forum and Zimbabwe, it's held that states will be held liable if they fail to exercise due diligence to protect its citizens, to investigate, to punish private actors when they commit violations against their citizens, Your Excellency. Also, we see that there's state knowledge of this harm and failure to prevent it because they benefited from it, Your Excellency. When the QHL came in to the Republic of EDERA in paragraph 10 of the fact of the case, it held that they said that
you need to be wrapping up.
Okay. What's about, Your Excellency? When QHL came, they said that they were going to relocate the Bashi people if they wanted at their own consent. But we see that state agents, acting in the interest of QHL, removed these people from their own ancestral lands. And in paragraph 9 of the case, we see that the Bashi people have been living in that place for 130 years, Your Excellency. Also in paragraph 19 of the fact of the case, we see that the army commander of the local government area of the Bashi tribe, Your Excellency, was working close in hand with QHL to intimidate the Bashi tribe to leave their own ancestral lands, Your Excellency. In the respondents, they assert that the JJCR recommendation was fully adhered to, Your Excellency, which was in paragraph 17 of the fact of the case, Your Excellency. But we see that the recommendation was that blastings of the QHL would halt until proper resettlement take place, Your Excellency. But it was not so in paragraph 18, as these people 5 months later, in paragraph 18, they were given rights to continue their blasting on the guise that they would start a new mining technique, Your Excellency. In paragraph 23 and 24, we see that no proper resettlement had happened, Your Excellency.
Yes.
And 2, Your Excellency.
Proceed. Hurry up and round up.
Much about, Your Excellency. No proper resettlement had taken place, Your Excellency. And we had to say in paragraph 24, the fact of the case, that these people had to live several hours from their own house, depriving them of their right to satisfactory environment in violating Article 24 of the Applicant Charter, Your Excellency. On the issue of child labor, Your Excellency, we see in paragraph 20 of the fact of the case that the truth defendants recorded 2,000 of these children, all aged 12 to 17, Your Excellency. We were working in this hazardous mining site, Your Excellency. State knew of this. The local NGO agitated that the Edera Mining Board look into these facts, Your Excellency, because 6 children died, Your Excellency. But the Edera Mining Board, they submitted that these findings were baseless, Your Excellency. In paragraph 26 of the fact of the case, we see that the voice notes released by Sisi, who was the girlfriend of the Minister of Land and Natural Resources, he provided the president had ulterior motives to remove Mapua from his own ancestral lands, Your Excellency, and give it to big corporations to enrich itself, Your Excellency. Violating the ILO Convention number 182, Your Excellency, that provides that children working in hazardous mining, the worst form of child labor, is also violated Article 15 of the African Charter on Welfare Right to Child, Your Excellency. It is the applicant's submission that the Republic of Edera failed to protect the Bashi community and the child workers from the violations meted by QH, Your Excellency.
Thank you so much.
No further assistance to this court, I would like to give it to my co-counsel to address issues 3 and 4, Your Excellency.
Thank you. Proceed.
Good day, Your Excellencies. My name is Alia Barua, and I'm appearing as the co-counsel for the applicant. I'll be addressing issues 3 and 4 and taking our reparations. With your kind permission, may I proceed?
Proceed, please.
Much obliged, Your Excellency. On issues 3, it is our humble submission that the Public Order Act of the Republic of Edera violates international human rights law. Your Excellency, we will be addressing this issue raising 3 submissions, Your Excellency. The first submission is the Public Order Act violates the right to assembly and association. Your Excellency, Article 10, Article 11 of the African Charter, Article 21 of the International Covenant on Civil and Political Rights, Article 5 of the United Nations Declaration on Human Rights Defenders, Article 20 of the Universal Declaration on Human Rights. All these provisions guarantee rights to association and assembly, Your Excellency. However, Section 13 of the Public Order Act requires organizers of protest to obtain permission at least 14 days from the IGP before carrying out a protest, and we submit that this is a clear violation of the various provisions of the African Charter and other relevant international human rights instruments, because apologies, Your Excellency, invest the exercise of these rights at the prerogative of the IGP, Your Excellency. On the second submission, the Public Order Act fails to
Can we quickly go back? Is the right to protest, is it absolute? Is your right to press, is it absolute? Is it an absolute right?
Much obliged, Your Excellency. Article 11 of the African Charter provides that the right to assembly is not an absolute right, provided that the restrictions are carried out in the interest of national security and public order, Your Excellency.
Okay, so who is supposed to determine national security and public order?
It is the state, Your Excellency. But however,
and
Your
the
Excellency,
IGP would be the one that has that right. So would you say that the state is wrong to ask for 14 days permission so that they can put logistics in place to ensure that the protest is peaceful?
Much obliged, Your Excellency, for the question. Your Excellency, the United Nations Special Rapporteur provides that what is expected is notification, Your Excellency, and not permission. And Your Excellency, as seen in paragraph 11 of the facts of case, section 13 specifically provides for permission and not notification, and this contradicts the international provisions of Article 10, Article 11 of the African Charter and the various relevant international human rights instruments, Your Excellency.
Proceed.
Much obliged, Your Excellency. The Public Order Act fails to meet the test of legality, proportionality, and necessity. Your Excellency, the United Nations General Comment number 37 provides that 3 tests must be met for a restriction I'm so sorry, Your Excellency. 3 tests must be met before a restriction can be deemed valid, which are the tests of legality, necessity, and proportionality. And it was also affirmed in the case of Kinvema versus Finland by the United Nations Human Rights Committee that restriction must be necessary and proportionate. And we submit that the Public Order Act fails to meet this test. On legality, Your Excellency, we submit that the Public Order Act is not valid as it gives the IGP excessive discretion to determine whether or not the protesters can I'm so sorry, Excellency. The protesters can exercise this right because it provides for permission, and permission in this case would mean that the IGP has the power to either grant the permission or not to grant the permission, Your Excellency. On necessity, we submit that there was no pressing need for restriction because, Your Excellency, as in paragraph 12 of the facts of the case, the protest was going on peacefully until the police started dispersing tear gas from paragraph 12 to paragraph 14 of the facts of the case, Your Excellency. On proportionality, we submit that the state's response to the protest was not reasonable as the use of tear gas was not proportionate in trying to maintain public order, Your Excellency. On our third submission, the Public Order Act renders the right to assembly illusory. Your Excellency, although the Nigerian Constitution guarantees civil and political rights as seen in paragraph 4 of the facts of the case, we submit that the Public Order Act renders this right meaningless, illusory, Your Excellency. Your Excellency, in the case of Civil Liberties Organization versus Nigeria, the African Commission held that restriction must never nullify the excess of the right, and it was also confirmed in the United Nations Special Rapporteur report, Your Excellency. And Your Excellency, as seen in paragraph 11 of the facts of the case, section 13 makes the exercise of this right subject to the approval of the IGP, a clear violation of the various provisions melted out in the African Charter and other relevant human rights instruments. Accordingly, it is our humble submission that the Public Order Act violates international human rights law. With your kind permission, Your Excellency, may I proceed to issues 4?
Yes, please.
Much obliged, Your Excellency. Your Excellency, it is a humble submission that either violated the African Charter and other relevant international human rights instruments by various treatment meted out on Mr. Jude and Mr. Marcos. Your Excellency, I'll be addressing this issue on 3 submissions. The first one is arbitrary arrest and detention. Your Excellency, Article 6 of the African Charter and Article 9 of the International Covenant on Civil and Political Rights guarantees rights to liberty and prohibits arrest without lawful justification, Your Excellency. And in the case of Amnesty International versus Zambia, Your Excellency, the African Commission held that instituting criminal proceedings for the purpose of silencing human rights defendants, it violates Article 6 of the African Charter and Article 9 of the ICCPR.
Can I ask you a question? The organizers of protests, don't they have also are they not supposed to ensure that their protests are done without thugs and to ensure that all the safety of other people are ensured while you're doing your protests? Is your right absolute? Because you have a right to protest, does it mean that you should scatter the whole country and make other people uncomfortable and people start throwing stones and thugs enter into your protests? You know, I keep asking, is that right absolute?
Your Excellency, the right is not absolute. But however, Your Excellency, as seen in paragraph 27 of the facts of the case, in lines 4, Your Excellency, it was stated that the scenario turned violent because the police who had been sent in to use tear gas to disperse the protesters were unable to handle it. So, Your Excellency, we submit that the violence escalated from the police, and Mr. Jude and Mr. Marcos should not be liable for police mismanagement, Your Excellency.
But they said they were blocking traffic and disrupting activities. So when Mr. Jude noticed that they were, and Marcos noticed that they were blocking traffic, shouldn't they have toned down their protests? Because the right of other people, where your own right starts is where my own right also starts. Your own right doesn't supersede my right. What do you think about that?
Much obliged, Your Excellency. Your Excellency, in the guidelines on freedom of association and assembly, it was held that the activities of third party may be temporarily hindered or obstructed for the purpose of exercising the right to assembly. And we submit that the blocking of traffic, Your Excellency, does not make a protest not to be peaceful, Your Excellency.
Blocking of traffic when other people have emergencies.
Yes, Your Excellency, as it was stated in the guidelines on freedom of association and assembly in Africa, we submit that the action was justified, Your Excellency.
Proceed, please. Thank you.
Much obliged, Your Excellency. In Amnesty International versus Zambia, Your Excellency, the African Commission held that state must not use criminal proceedings to silence human rights defenders. But Your Excellency, in paragraph 27 of the facts of the case, Mr. Jude and Mr. Marcos, as Mapoa leaders, came out to protest against the government plans to take away their ancestral land, and seen in paragraph 26 and paragraph 27 of the facts of the case. However, Your Excellency, due to the events that occurred in paragraph 27 of the facts of the case, which was caused by the police, Mr. Jude and Mr. Marcos were tried and convicted under Section 18 of the Indian Constitution, as seen in paragraph 28 and paragraph 29 of the facts of the case, without any evidence to show that they willfully or in any way destroyed government property, or any evidence to show that there was mens rea or actus reus, which is required in proving criminal liability, Your Excellency. And we submit, Your Excellency, that this violates Article 6 and Article 6 of the Applicant Charter and Article 9 of the ICCPR. Your Excellency, discrimination through selective enforcement. Article 2 of the Applicant Charter and Article 26 of the ICCPR guarantees equality before the law. Your Excellency, as seen in the case of media rights and
you are speculating. The law, the facts does not say that there was no evidence. You are speculating. The fact that doesn't state that there was no evidence. They said they were charged with destroying government property.
Your Excellency, as seen in paragraph, much obliged, Your Excellency, as seen in paragraph 27 of the facts of the case, there was no any fact that shows that Mr. Marcos and Mr. Jude were the one that initiated violence. So we submit that there was no evidence to show that they willfully or in any way destroyed government property.
Thank you.
Much obliged, Your Excellency. Your Excellency, we see in paragraph 27 of the fact of the case that similar organizations were present at the protest. But it is shocking to the applicant that only Mr. Jude and Mr. Marcos were arrested and convicted. And we submit that the state acted discriminatorily, and this was not just selective, but was targeted at them because they were human rights defenders speaking up for the Bashi community and not for any proven offense. Your Excellency, on our last submission regarding issues for violation of the right to fair trial, Your Excellency, Article 14 of the ICCPR guarantees right to a fair and impartial tribunal. And in the case of Mohammed versus Tanzania, this honorable court held that fair trial is respected where there is an impartial court. But Your Excellency, as seen in paragraph 22 of the fact of the case, reports by true defenders show that the judiciary are influenced by both politicians and corporations, Your Excellency. And we might as well conclude that the decision given by both the High Court and the Court of Appeal in paragraph 29 of the facts of the case was influenced by external factors. Accordingly, it is our humble submission that Republic of Idera violated the African Charter and other relevant international human rights instruments by various treatment meted out on Mr. Jude and Mr. Marcos. Your Excellency,
that is also speculatory. Thank you very much, but that is also speculatory because you are just basing your assumption on a newspaper report. On a report, there is no evidence to show that there was corruption in the judiciary.
Your Excellency, in paragraph 22 of the facts of the case, the report by true defenders provides that the judiciary is heavily influenced by big corporations. And Your Excellency, I would like to plead to this honorable court to agree with me, because I've seen in paragraph 19 of the facts of the case, the true defenders are NGO with consultative status, which consultative status as the UN ECOSOC. So I would plead this court to agree with me that we can rely on the reports by truth defendants, Your Excellency.
Without any sting operation or evidence. Thank you. Thank you so much.
Much obliged, Your Excellency. May I proceed to our prayers and reliefs?
Yes, please.
Much obliged, Your Excellency. The applicant respectfully prays to this honorable court to order the immediate release of Mr. Jude and Mr. Marcos and the annulment of their conviction, to declare the withdrawal of Article 34, Subsection 6 invalid, and to order Republic of Idera to provide rehabilitation and compensation to the victims of the 2019 and the 2025 police violence, the children laborers, and also the Bashi community for the losses they suffered due to the mining activities by QHL. Much obliged, Your Excellency.
Thank you very, very much. Thank you. Thank you, ladies.
Thank you,
Much
Your Excellency.
much obliged, Your Excellency.
Thank you. Does anyone have any question for the ladies? Okay. I think we can proceed with the next team.
Team 13, please. You need to speak up now. Team 13. Oralist 1 and 2 for Team 13.
Pardon me, Excellency. I thought my camera was on.
Who are you?
Lead counsel for Team 13, Your Excellency.
Where is your second oralist?
She's on the call, Your Excellency.
Both of you are expected to be together by the rules of this court.
We already informed the organizers that we are currently on break and we are living in different states, Your Excellency.
Okay, please go ahead. Thank you.
Thank you, Your Excellency. With great reverence to this honorable court, I am D.O. Ojarotade, lead counsel for the respondent, Republic of Edera. While I'll be addressing this honorable court on issue 1 and issue 2, while my co-counsel, N.D. Akindele, will be addressing this honorable court on issue 3 and issue 4. Counsel hereby seeks the view of this honorable court to adopt as well as adopted a brief of argument.
Proceed, please.
Thank you, Your Excellency. Your Excellencies, counsel will now address this honorable court on the jurisdiction of this court and admissibility of this matter, while alongside with issue 1, which is whether the withdrawal by the Republic of Edera is valid. Your Excellencies, before any engagement with the merits, the respondent respectfully submit that the application before this honorable court collapses at the threshold for 2 fundamental reasons. 1, that this honorable court lacks the jurisdiction to accept the applicant's application following the respondent's valid and effective withdrawal of Article 34 Sub-6 declaration of the protocol. 2, that the application is inadmissible owing to a clear failure to exhaust available, effective, and sufficient domestic remedies. These are foundational jurisdictional bars, without which this honorable court cannot proceed. Your Excellencies, the jurisdiction of this honorable court is provided for in Articles 3 of the Protocol to the African Charter on Human and People's Rights and Articles 34 Sub-6 of the Protocol, which allows individuals and non-governmental organizations to bring cases before this honorable court, provided that the state party has made a declaration to that effect. However, where a state party has not made such declaration or has withdrawn such a declaration, no such application can be filed by an individual or non-governmental organization before this honorable court. Your Excellencies, the facts are unequivocal, as provided for in the MOOT record paragraph 29. On August 15, 2025, President Simforosa publicly announced that the Republic of Edera has withdrawn its Article 34 Sub-6 declaration. Your Excellency, the applicants filed their application after this withdrawal was made, and the application was filed on 22 August 2025, Your Excellency. This
Is there a procedure for withdrawal?
yes, Your Excellency.
And was that procedure for withdrawal followed?
In the case of Ngabaya, Victoria, versus
No, I'm asking is in the article, in the charter, is there a procedure for withdrawal when the state wants to withdraw?
No, Your Excellency, there is no such procedure provided for in the article.
There is no procedure for withdrawal.
So
the president can just on his own say, I'm withdrawing, and that's it.
By provision of Article 34 sub 6 of the protocol to the African Charter, the withdrawal can be withdrawn at any time. No procedure was attached to the provision of Article 34 sub 6, Your Excellency.
And how long does that procedure take before it takes effect?
12 months after notice has been given to this honorable court.
Okay, so 12 months after notice has been given, and when was the action filed?
The action was filed by the applicant on 22 August 2025.
When was the withdrawal done?
August 15, 2025, Your Excellency.
Had 12 months elapsed?
Your Excellency, it's not expressly stated in the MOOT record. However, Council will rely on the presumption of regularity, Your Excellency, that official acts have been done in line with due procedures, Your Excellency.
Proceed. Thank you.
Thank you, Your Excellency. Your Excellency, at the moment of filing, this court no longer possessed competence to receive direct application from individuals and non-governmental organizations against EDERA. This position is non-novel. It represents and reflects this court's own jurisprudence. In the case of Ngabaya Victoria versus Rwanda, the African court affirmed that state parties can withdraw Article 34 sub 6 declarations as they are voluntary and optional. This is precisely the scenario before this honorable court. Our brief of argument, issues 1, paragraphs 1.2 to 1.4, emphasize that under Article 54 to 56 of the Vienna Convention on the Law of Treaties, a state may withdraw a declaration made unless expressly prohibited. However, Article 34 sub 6 declaration contains no such prohibition, Your Excellency. And as such, Your Excellency, the withdrawal is valid under treaty law, recognized by this court's own jurisprudence and effective prior to the applicant's filing. Respectfully, jurisdiction cannot be retroactively revived. And as such, this honorable court lacks the jurisdiction to hear and determine this matter brought before it by the applicant, Your Excellency. Your Excellency, on the matter of admissibility, assuming without considering that jurisdiction indeed exists, the application still fails by virtue of Article 56 sub 5 of the African Charter on Human and People's Rights and Rule 50 sub 2E of this honorable court, which provides that before an application can be filed before this honorable court, local remedies must have been exhausted, Your Excellency. However, Your Excellency, this requirement has not been met by the applicant. In the case of World Organization Against Torture and Others versus Zaire, Communications number 25/89, the African Commission emphasized that exhaustion of local remedies is fundamental to its admissibility criteria. The Commission went further to hold that complainants must exhaust all available effective local remedies before bringing a communication to this court.
In which case was local remedies not exhausted?
Your Excellency, World Organization Against Torture and Others versus Zaire.
No, I'm saying in this particular fact, where was local remedies not exhausted? Because I know Mr. Bashir, and in Mr. Bashir's criminal case, they exhausted all local remedies.
Your Excellency, paragraph 6 of the MOOT record empowers the Supreme Court of the Republic of Edera to hear and determine on matters relating to constitutional questions and human rights questions. It serves as a court that has appellate jurisdiction for matters that have been decided by the Court of Appeal. Your Excellency, after obtaining judgment from the High Court and the Court of Appeal, the applicant failed to respect the hierarchy of courts in the Republic of Edera and jumped over this particular hierarchy to approach this honorable court, showing complete disregard for the established judicial system in the Republic of Edera. And as such cannot be said to have exhausted all available local remedies in the Republic of Edera, Your Excellency.
Proceed.
May I proceed? Thank you, Your Excellency. Yeah. Your Excellency, there is no evidence of undue delay The judicial strike mentioned in record paragraph 21 did not cause delay in remedy. At the time remedies were available in 2024 to 2025, the matters of the applicant, Your Excellency, was attended to immediately without undue delay on the part of the respondent, Your Excellencies. Your Excellencies, as such, the failure to exhaust local remedies is neither justified nor excusable. And as such, premature internationalization of domestic matters is not allowed and is inadmissible, Your Excellencies. Going by this, Your Excellency, the applicant case is inadmissible by virtue of Article 34 sub Article 56 sub 5 of the African Charter and Article 50 sub 2E of the rules of this court. And Your Excellency, should this court elect to proceed, the respondent position remains unwavering that the jurisdiction, the matter before this honorable court is this honorable court last decision to hear this matter, and the case itself is inadmissible. And also the withdrawal of Article 34 sub 6 declaration of the protocol by the respondent is valid in law, Your Excellencies. If the court has no further questions for me, counsel will thereby proceed to issue to Your Excellencies. Your Excellency?
I'm with you.
May I proceed to the second issue, Your Excellency?
Please do.
Thank you, Your Excellency. Your Excellency, on issue 2, whether EDERA violated the African Charter on Human and People's Rights and other human rights charters by failing to protect the Bashi people and child workers from QHS abuses. We respectfully submit that the Republic of EDERA has not violated the African Charter or other human rights instruments. The applicant is trying to paint EDERA as indifferent. However, Your Excellency, the respondent's brief of argument, issue 2, shows step by step, paragraph by paragraph, that the Republic of EDERA has indeed acted. Indeed, the Republic of EDERA did not neglect the citizens from QHL's abuses, Your Excellencies. Your Excellency, in the case of SERAC versus Nigeria.
Can I quickly ask you a question? How did they act?
Yes.
If the children were in school, if the children's fundamental right of a child has a right to education,
Yes,
a child has a right to a clean and decent environment. If the children had the right to education and their education was being met and they were in school, they probably wouldn't have been working. Would they have been working? So how has the state met the children's basic rights? Because you say they were trying to paint the state black. Doesn't the state itself has a duty and obligation to those children? If the state had met its duty and obligation to the children, would they have been taken advantage of by local minors?
Your Excellency, to start with, the right to education is a non-justiciable right. And apart from that, yes, Your Excellency, everyone has a right to be educated, but it is not forced on people. It is up to the nation makes the law. It is up to the parents to ensure their children are actually in school, Your Excellency.
Do you know that every state has, well, if that is what you're saying, every state has a right to protect the best interest of a child. So if the best interest of those were being met by EDERA, would they have been on the streets?
Your Excellency, one of the foundational principles of international laws and charters is eradication of poverty and illiteracy. However, these actions, Your Excellency, are not immediate actions. They are to be taken step by step. They are progressive actions. And by provision of Article 2 sub 1 of the International Covenant on Economic, Social, and Cultural Rights, that states are not expected, the legal obligation of state is one of progressive realization and not immediate realization, Your Excellencies. And it's also important to note that EDERA is a developing economy, Your Excellency, by paragraph, as explained in paragraph 1 and paragraph 3 of the MOOT record. So, Your Excellency, EDERA has done its duty as a nation to ensure children have rights, to have their own rights. It is, however,
what rights? What rights?
Their rights to their fundamental human rights, like right to life, right to dignity, right to personal liberty, right to education, Your Excellency.
Right to dignity and right to life, but they're they are working in the mines. Does that give them
As
right to dignity and
as
right
earlier
to life?
stated, Your Excellency, the state makes the law. It is in such situation, it also falls on the parents. And it's also important to note that these children are not direct employees of Queensland Holdings Limited. They are
Regardless of the
informal.
facts,
Yes,
the
Your
state
Excellency.
still has obligations to those children. But proceed.
Yes, Your Excellency. Thank you, Your Excellency. Your Excellency, the African Commission in Serac versus Nigeria made it clear that states are obliged to take reasonable, Your Excellency, reasonable measures and not perfect measures to prevent, investigate, and redress alleged violations. Your Excellency, the question is not did the harm occur. The right question to ask is, did the state act reasonably in the face of risk? And the record shows that Edera consistently did. Your Excellency, in paragraph 17 of the MOOT record, it shows that the Republic of Edera, after the 2019 incident, established the Jacob Jeffrey Commission of Inquiry, which looked into the incidents that occurred during the 2019 riots, where officers like Triplett and Bernard were shown as officers who committed treasonous actions during these protests, Your Excellencies. This commission also recommended sanctions, and the state enforced them. Your Excellency, this demonstrates accountability and transparency, and not negligence as alleged by the applicant, Your Excellency. It's also important to note that the Republic of Edera suspended blasting operations by Queensland Holdings Limited for 5 months. And this can be found in paragraph 18 of the MOOT record. 5 months, Your Excellency, until safety measures are provided by Queensland Holdings Limited. And after these measures were provided, blasting operations resumed 5 months after, Your Excellency. And allegations by the applicant that the Republic of Edera was collaborating with Queensland Holdings Limited to oppress the citizens are mere allegations without proper evidence, Your Excellency.
You need to start rounding up.
Thank you, Your Excellency. Lastly, Your Excellency, on the matter of child labor, as earlier stated, the Edera Mining Board investigated the allegations, paragraph 22 of the MOOT record, and found them unsubstantiated. And in the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, the state is responsible only if it endorses private abuse. However, Edera did neither of this. Your Excellency, in conclusion, when the facts are viewed holistically and the law are properly applied, a clear picture emerges. Edera acted reasonably, transparently, and in good faith. Your Excellency, the African Charter or any other instrument were complied with by the Republic of Edera. And we urge this honorable court to hold that the Republic of Edera did not violate the African Charter and other instruments. We urge this honorable court to so hold. Counsel ever seek the leave of this honorable court to differ proceedings to my co-counsel ND Akindele, who will address this honorable court on issues 3 and issues 4. Thank you, Your Excellency.
Thank you. Thank you so much.
With profound respect to this honorable court, I remain ND Akindele. I'll be taking issue 3 and issue 4, Your Excellencies. On issue 3, Your Excellencies, whether or not the Public Order Act of the Republic of Edera violates international human rights law. On behalf of the respondent, the Republic of Edera, Counsel humbly submit that the Public Order Act of the Republic of Edera does not violate international human rights law. Your Excellencies, this present claim under issue 3 is inadmissible by this court because of the failure of the applicant to fulfill the condition of exhaustion of local remedies as required under Article 56, subsection 5 of the African Charter on Human and People's Rights. Your Excellency, the exhaustion of local remedy condition is an essential condition which must be met by anyone bringing a claim before this honorable court, before the claim can be admissible in this court. And the applicant has not shown that there was no avenue for them to exhaust all local remedies before the claim was brought before this honorable court. On merit, Your Excellencies, the applicant contends that the Public Order Act of the Republic of Edera does not violate international human rights law. Your Excellencies, it is trite that no right is absolute. Every fundamental human right is subject to one limitation or the other. Your Excellency, the right to peaceful assembly is guaranteed under Article 11, of the African Charter on Human and People's Rights,
and Article 21 of the International Convention on Civil and Political Rights are not absolute rights, Your Excellencies. Your Excellencies, they are subject to certain restrictions which are in conformity with the law and necessary in a democratic society in the interest of national security, protection of the rights and freedom of others, and protection of public order and public peace. Your Excellency, to further emphasize on this, Your Excellency, relying on this rule in the case of Law Office of Gaza Suleiman versus Sudan, the African Commission held that restrictions to the exercise of the freedom of assembly is legitimate where it is in the interest of national security and the protection of the rights and freedom of others. Similarly, Your Excellency, this court in the case of Tanganyika versus
Tanganyika.
Yes, Your Excellency.
Continue.
Much obliged, Your Excellency. This court in the case of Tanganyika Law Society and Legal and Human Rights Center and Reverend Christopher Umtikila versus Tanzania, this court held that the state has a positive obligation to create legal frameworks enabling citizens to protest. However, the state should also put in place legal frameworks to protect the rights of others and to preserve public order. Your Excellency, in this instance case, Your Excellency, in this instance case, the public order, the Constitution of the Republic of Idera, in line with international human rights standard, recognizes citizens' rights to peaceful assembly, and it also has in place certain lawful restrictions which are in the interest of national security and protection of the freedom and rights of others. Your Excellency, Section 13 of the Public Order Act requires prior permission from the Office of the IGP before a protest can be conducted, not to cripple the rights of the citizens, Your Excellency, but to protect the protesters and to ensure that there is strict adherence to ensure that there is no breach of peace or the violation of the rights and freedom of others. Your Excellency, the applicants argued that the protest was peaceful. The applicants argued that the Public Order Act is a crippling device to the exercise of the rights to freedom of assembly of the citizens, Your Excellency. However, in this instance case, the protest, which was unauthorized, that was organized by the MAPOA members, led to the death of 5 civilians, Your Excellency, death of 5 civilians and severe injuries to 30 civilians and 5 policemen.
Death of 5 civilians, but it was as a result of the use of force by the police.
Yes, Your Excellency.
Use of tear gas and force. It was not the civilians that were shooting each other, or it was not as a result of their own actions. It was as a result of the action of the police that the death of civilians occurred.
Yes, Your Excellency, but as stated in paragraph 27 of the MOOT Fact, Your Excellency,
yes,
the protest was violent, and the South Sudan were already throwing stones at the police officers. They had to come in. The forces that were commanded by General Tony had to come in to disperse the riot, Your Excellency. It was already getting too violent, and it was leading to breach of national security and the right and freedom of others, Your Excellency. So
but it's not you need to use live ammunition. They could have used rubber bullets and tear gas.
Your Excellency, they were already throwing stones, Your Excellency, and stone is the throwing of stone in that much of a place that was that crowded is a threat to life, Your Excellency. And since the rioters were not ready to pass, much obliged, Your Excellency. Your Excellency, you could please the use of the protest led to the death of 5 civilians, caused severe injury to 30 civilians and 5 policemen, and even led to arson, the crime of arson, because a police van was set on fire, Your Excellency. The fire could have escalated, Your Excellency, even not because of the intervention of the armed forces. Your Excellency, this is the proof of the dangers attached with unregulated protest, Your Excellency. Because, Your Excellency, the provisions of Section 13 of the Public Order Act of the Republic of Idera is necessary to ensure regulation of protest, preserve public order, and preserve the rights and freedom of others. Your Excellency,
when protest is over-regulated, doesn't it affect free speech? When you are over-regulated, and you want to protest against government action, and you still need to go to the government to ask for permission to protest against the action of the government, will the government give you permission to protest?
Your Excellency, the permission requirement is in place Sorry, Your Excellency.
No
The
problem.
permission requirement is in place, Your Excellency, to protect the citizens, not stop them from going on protest, from protesting. Your Excellency, the residents of Bashi didn't even make any attempt at all to get that permission. So even if the permission will be denied, they didn't get it at all. They just went on the protest, and it led to something else, Your Excellency. So, Your Excellency, this regulation is not a crippling agent, Your Excellency. It is just to ensure that everything is in order, to prevent disorder, Your Excellency.
Yes, continue.
Consequently, Your Excellency, respondents humbly submit on behalf of the Republic of Idera that the Public Order Act of Idera does not violate international human rights law, and the applicant also submit that the claim lacks merit and is therefore inadmissible before this court. And we urge this honorable court to so hold. With the kind permission of this court, counsel seeks to proceed to issue 4.
Yes, please.
On issue 4, Your Excellencies, whether or not the Republic of Idera violated the African Charter on Human People's Rights and other relevant international human rights instruments by the various treaties meted out on Mr. Jude and Mr. Marcos. On this issue, counsel submits on behalf of the respondent that the Republic of Idera did not violate the African Charter on Human People's Rights and other relevant international human rights instruments by the various treatment that was meted out on Mr. Jude and Mr. Marcos. Your Excellencies, the right to personal liberty is guaranteed under Article 6 of the African Charter on Human People's Rights and Article 21 of the International Convention on Civil and Political Rights. However, Your Excellency, this right is not absolute, as it is subject to certain deprivations for reasons and conditions which has been previously laid down by the law, Your Excellencies. To further emphasize this, Your Excellencies, Article 29, subsection 3 of the African Charter on Human People's Rights imposes duty on individuals not to compromise the security of the state. Your Excellency, in this instant case, the restrictions and deprivations imposed by the government of Idera was lawful and necessary to preserve public order and public peace. Your Excellencies, Mr. Jude and Mr. Marcos were arrested and prosecuted pursuant to Section 18 of the Criminal Code Act of the Republic of Idera for willingly destroying government properties. Your Excellency, the Criminal Act is the major legislation on criminal offenses. It's the major legislation on criminal offenses in the Republic of Idera, and it is valid, Your Excellency. Your Excellencies, the arrest of Mr. Jude and Mr. Marcos was lawful and necessary to prevent further chaos, as the riots was already escalating and it already led to the loss of lives and grave injuries to people.
But the other touts and other people's throwing stones were not arrested. Why is it only the conveners of the riots that were arrested? The people that obviously committed the crimes of throwing stones, the touts that were there, why were they not arrested?
Excellencies, in a situation like this where a lot of crowds are there, it is not easy. It won't be easy to differentiate the protesters from the touts, Your Excellencies. Your Excellency, they didn't have anything showing that they are the touts, differentiating them from the touts. There was nothing to differentiate the touts from the protesters, Your Excellency. That was why the leaders were arrested, Your Excellency. They were the ones that were recognized. They were the ones that organized the protest, Your Excellency. So they were the ones that would be responsible for the act of others. Your Excellencies, there was no way for the policemen and the other armed forces to differentiate the protesters from the touts, Your Excellencies.
Proceed.
Much obliged, Your Excellencies. Your Excellencies, Mr. Jude and Mr. Marcos, as leaders, as protesters and leaders of the protest, not only compromised the security of the state, they also orchestrated the death and injury of several people. And as it is trite, Your Excellency, that the welfare of the people is the supreme law, the arrest and detention and prosecution of Mr. Jude and Mr. Marcos was not arbitrary, rather, it was necessary and lawful to prevent public disorder. Your Excellencies, the applicants argued that Mr. Jude and Mr. Marcos were not involved they did not involve themselves in any violent activities, that they just organized a lawful and peaceful protest. However, Your Excellency, it is trite, based on the doctrine of command responsibility, that leaders, but the doctrine of command responsibility, which is a well-established principle of the international law, that leaders will be held responsible and liable for the criminal act of their followers, of subordinates, if they fail to exercise reasonable measures or control their subordinates from engaging in violent acts. Your Excellencies, in this instance case, Mr. June and Mr. Marcos are the leader and deputy, is the chairman. Mr. June and Mr. Marcos are the chairman and deputy chairman of the MAPOA association, and they were the ones that organized and led the protest. However, Your Excellency, instead of them to exercise proper control, to put in place safety measures to make sure that this protest does not graduate into a riot or any other violent act, they failed to do this, and this led to the breach of public peace and the loss of lives and injury to several others. Your Excellency, Mr. Jude and Mr. Marcos, in a protest as such that was organized where it already commenced with the disruption of activities and blocking of traffic, Your Excellency. That alone is a violation of the rights of others. However, Your Excellency, a protest that started in that manner, it is foreseeable that such protests will become violent, Your Excellency.
Yes.
And instead of putting in place measures to prevent this, Mr. Jude and Mr. Marcos failed to do this and went on with the protest, Your Excellency. Thus, Your Excellency, based on the doctrine of command responsibility, Mr. Jude and Mr. Marcos failed to prevent their subordinates from going violent and as held in the case of Ezelin versus France, Your Excellency, the organizers of protests are obligated to make sure that the protest does not become violent, to put in place safety measures to make sure the protest does not become violent. And Mr. Jude and Mr. Marcos failed to do this. Thus, Your Excellency, the arrest and detention and prosecution of Mr. Jude and Mr. Marcos was lawful and not arbitrary. Your Excellencies,
You need to start rounding up.
Humbly and respectfully submit that the Republic of Idera has not violated the African Charter on Human People's Rights and other relevant international human rights instruments by the various treatments that was meted out and Mr. Jude and Mr. Marcos. Idera acted with utmost fidelity to its domestic laws and international obligations, firmly and justly in legitimate interest of preserving public order and the right of others, and may this honorable court so hold. With the kind permission of this court, counsel seeks to defer proceedings back to my lead counsel.
Okay. Why do you want to defer to your lead counsel?
For the conclusion, Your Excellency.
Okay. Okay.
I remain DO Your Excellency, and I'll be addressing this. I'll be taking the conclusion, Your Excellency.
You just have 1 minute.
All right, Your Excellency. Your Excellency, the path to correct outcome is unmistakable. The respondent has met the law, the applicant has not, and the record leaves no room for doubt. On this, we conclude that one, the applicant environmental and human rights defenders claiming the Republic of Iberia withdrawal of Article 34 subsidies declaration is invalid. Is not strong in law, Your Excellency. We conclude that the withdrawal of Article 34 subsidies declaration by the Republic of Iberia is valid. Two, Your Excellency, the allegation that the Republic of Iberia failed to protect the Bashi people and children from child labor is unfounded, Your Excellency. And we pray all these honorable courts to hold that the allegation is unfounded. Three, that the Public Order Act is constitutional and not against human rights charters, Your Excellency, and the right to freedom of assembly. And lastly, that the actions meted on Mr. Jude and Mr. Marcos were lawful and that they were entitled to fair trial, Your Excellency. Your Excellency, on this note, we pray this honorable court that the prayers included in our brief of arguments be adopted and decided upon, and we pray this court so good. Thank you, Your Excellencies.
Thank you very much. Thank you very much. Thank you very much. So I think Team 19 would do their reply. That should be reply on points of law.
Much about Your Excellency. My name is Precious Emmanuel, appearing as applicant, Your Excellency. And we are reporting, Your Excellency, at the moment. The respondent tries to mislead this honorable court that there was no undue delay. But in the facts of the case, paragraph 21, line 8, there was gross undue delay, Your Excellency. This is contrary to the rule that is established in Jawara and the Gambia, that where there's undue delay, that these remedies are insufficient and ineffective, that there be no need for the exhaustion of local remedies, Your Excellency. Also, The respondent asserts that on the issue of 12 months notice, that the Article 34 of 6 declaration is valid, Your Excellency. But it was, and they assert that there's no provision for it in the African Protocol. But this African Court, Your Excellency, which we are before, has affirmed, Your Excellency, in Inagbere and Rwanda, Your Excellency, that the Article 34 of 6 declaration would only take effect only after 12 months, Your Excellency. In the fact of the case, we see that the application was filed on the 2nd of August, while the withdrawal took place on 15th of August 2025, Your Excellency. Also, the respondent claimed that the state took adequate steps by following and adhering to the JJCR recommendation, Your Excellency. But we see that not all of these recommendations were followed, Your Excellencies. These adequate steps that the state claimed they took was not sufficient, Your Excellency, because we see in paragraph 23 and 24 of the fact of the case that there was environmental degradation still, even after the implementation of the JJCR, Your Excellency. The people lacked their right to access to food and access to good water, oil, and good soil, Your Excellency. And in section 32 of the Constitution, it says that the states are obligated to provide good water, soil, and land for these people, Your Excellency. This expands to the right to life, Your Excellency, which is the ground right to all other rights, Your Excellency. If these citizens, Your Excellency, they're unable to enjoy right to access to good land, water, and food, Your Excellency, it undermines and violates the right to life, Your Excellency. The respondent also claims that we didn't try to get permission, Your Excellency. But in General Comment number 37 of the UN Human Rights Committee, it upheld notice requirements, which was done in paragraph 10 of the fact of the case. We see that these residents of the Bashipu came out to the public to announce that they wanted to take a public protest if the government does nothing about their plight, Your Excellency. This suffices the notice requirement upheld in General Comment number 37, Your Excellency. It is the applicant's submission, Your Excellency, and urges the courts respectively to hold that the respondent is responsible and to protect the rights of the people of Edera. Much obliged, Your Excellency.
Very much. Thank you very much. Thank you very much, ladies, once again, for your oratory skills. Thank you. And I'm impressed that I have two ladies. In fact, today, I also have another lady in the other team. So I'm impressed that I have three ladies before me. Interesting. So I think that's it for your for this round. I can hand over to the host now. I think that's it. Thank you.
Your Excellencies, if we have comments for the oralists, this will be the right time for them to know how they're fed before we knock them off the session, sirs. Thank you, Your Excellency.
Okay, let me start with the team 19. Team 19, that's Precious. I think Precious she knew what she was doing. She came out strong. Halia was a bit, I think she also knew what she was doing, but she didn't have particularly great oratory skills. Maybe she was a bit not too confident, but towards the end, she pulled through, and that was very good. For team 13, the guy Dio Ojatade was very good. He had good oratory skills. He spoke very well, and he was very sharp, and he was able to wiggle away, although not particularly on points of law, but he was able to wiggle his way around the questions asked. Also, the lady in India Kidili was also good. All in all, I think all of you performed well. You all performed very well, and thank you for your oratory skills. I'm impressed that you all seem to have advocacy skills, which is very important for a lawyer going forward. So that's a good point that I note, that as young lawyers to be, you all seem to have good advocacy skills. Thank you. So the other two judges can please state their point.
Yeah, thank you very much. I agree they all have oratory skills and advocacy skills. For the applicants, team 19, Precious Emmanuel, very sound and was able to quickly respond to questions asked by the judge, and that was very impressive. Also, Alia Barua. Well, I think what happened to her was maybe she had some level of fright or something, but she tried at the end of the day to try to convince us about her points. So yeah, the applicants did well. For the respondents, Daniel Oluwatobiloba, yeah, he spoke convincingly. Yeah, like the judge said, he tried to run away from the legal questions. Well, he tried to speak convincingly about his arguments and clearly has oratory power and clear advocacy skills. He was able to drive home his points, even if he didn't necessarily answer the questions asked. Also, Deborah Akindele, also very good, marshaled her points quite clearly, and I think on the average, they all did well, and they have a very promising future in legal practice if they decide to choose it as their profession going forward. Thank you.
Thank you very much. I recognize the lead judge and also my Dr. Winga. Okay. So I'd just like to commend the students. I think they did excellently well in their presentation and their submissions. Team 19, they were very confident and calm, and your delivery was good. I like the fact that you had answers to the questions that were posed to you, and you did that with some level of speed and promptness. So team 13, but I think you were very confident of yourself. You had you equally tried your very best to attend to the questions that were posed before you. New song Akindele, yes, you did very well. You did very well too. I think generally and overall, you guys are good, and I'm confident that you'll be able to pull through. Thank you.
Thank you, Excellencies. While please, may I request that the oralist from team 13 and 19 exit the session, this virtual courtroom, and leave us with the judges. Team 13, team 19 oralists. please kindly exit. Team 13 observer, please leave. Thank you. Thank you, Your Excellencies. We appreciate you so very much for honoring our invitation. We'll be excited if we can get the score sheet as soon as possible to the email address that's PILIWA. To the email address, and if I need to share that with us, I also do that. Like I said when we started, the score sheets are in two. Score sheet for applicants, score sheet for respondents, and each oralist are graded independently, all over 100. So would appreciate if we can get that so that we can compile our records. Thank you so much, Your Excellency.
Thank you very much.
Yes, we appreciate you, Mas. Thank you, sir.
Thank you.
Thank you very much. Thank you.
Thank you. Thank you for honoring our invitation. Thank you.
You're welcome. You're welcome.
Thank you so much. Yes, sir. Yes, ma'am.